He wasn't in this
can't
movie.
win this one.
He should have been in this
She's in
movie,
both.
and then it would have been a real competition.
Yes.
Yeah, no, you have to meet it with luck, strategy, manipulation.
Calling for you.
I always wanted to work with Barbara for that reason. So I read the script and loved it, obviously. And then I begged Barbara to meet me, and I called Reed and I was like, listen, I know you're doing another movie and I'm supposed to be doing another movie. Let's be honest, neither one of us want to be in those relationships. So let's do this movie instead. If Barbara's willing to hire us both, would you want to go in together and say, like, look at this, you got both of us? And she was like, yes, I would love to make this movie with you. So
Hi, besties. It's Katie from Without a Crystal Ball. Blake Lively's case will never go to trial. Ever. Mark my words. And Justin Baldoni's legal team has signaled what their next plan of action is. It was in a letter. It was to the court, and it had to do with the unsealing of a document by Melissa Nathan, which showed to Blake who was on her list of journalists and content creators that she may have spoken with. Now, a list Melissa had provided back in June contained the names of journalists from multiple outlets: Candace Owens, Perez Hilton, Billy Bush, and Dumois for like content creators. But she had to modify that, and she had to add other people and include content creators. And so the list then included one more person. And the only person that received a subpoena that Blake's team was being difficult to was Andy Signor. So my belief is that Andy was added to that list because when Justin didn't file any amended complaints, Andy put out a statement that he had received from Wayfair. And because he had received a statement from Wayfair, it's likely that it came from Melissa Nathan or was, somehow in contact with the PR side of things. He said it came from Brian Friedman's office. Brian Friedman's office is saying that their communications are going through Melissa Nathan. So Andy is likely that content creator on there, even though the first list named Candace and Perez, I'm pretty confident Andy's on there because he was then included in a document subpoena, okay? Because of that statement he got from them. Okay, so she outed that it was Andy that was on this list. A lot of you disagreed with me, but once it's unsealed, I'm pretty sure you'll find his name on there. Mark my words. And if I'm wrong, I will apologize. But when Wayfair sent the letter to them, and by the way, that letter was phenomenal, and I talked about it yesterday in a video. I want to just touch on something that they spoke about in that letter, because what it tells me is that Wayfair has a new strategy, and it's not that they're going to go to trial. And the reason why they're not going to go to trial is because they're going to be able to get rid of this case at summary judgment level. And summary judgment level is a way to have a case ended when discovery is completed. So once all discovery ends and motions for summary judgment are due after that, okay? And they've already told the court they're going to file a summary judgment because they're preparing one. It's a part of the process to get rid of a case that is more robust than a motion to dismiss, because by the time you finish discovery, you can tell a court without a doubt if there's a dispute. Okay. So they've notified the court that they're going to likely file a summary judgment. Kevin Fritz mentioned this a couple weeks ago when they were fighting about the deadline for discovery, because he was mentioning the deadlines for summary judgment. Okay. So what is summary judgment? It's a legal ruling by a judge, and it resolves a case before it goes to trial. And it happens when one party argues that there's no material facts in dispute that require a trial to resolve, and that they are entitled to judgment based on the law alone. What it does is it saves time and resources, and it can narrow down the issues. What it tells the court is that there's no general dispute of material facts. So a material fact is one that could affect the outcome of the case. If there's any reasonable dispute over such facts, it would be improper, and they are entitled to judgment as a matter of law. So even if facts are viewed in light most favorable to the opposing party, the law requires that the moving party to win. And they'll view all the evidence in the case most favorable to Blake. So what does it no genuine dispute of material facts mean? It means that there is a genuine dispute would mean that there's a real substantial disagreement about a fact important to an outcome, not just a trivial or speculative disagreement. A material fact is one that could affect the final decision and whether a contract was signed, whether a statement was made, or whether harm occurred. If there's conflicting evidence on a fact, then and people could maybe misinterpret that differently, then it might be denied. Okay. So why did he say and how did he tip off the court that he's thinking about filing a summary judgment? Simple. According to a motion, a core component of Lively's claims is the Wayfair parties are engaging in a smear campaign to somehow manipulate the apparently whole worldwide media landscape using untraceable sources to portray her as the wrongdoer. And they are characterizing the campaign as untraceable and not only defies common sense, but it given that Lively knows precisely which news articles or stories that she takes issue with, but also undermines any justification for her ongoing effort to use this court and the federal rules of civil procedure to discover the untraceable. Basically, what they're arguing is that her entire case is built upon a false and faulty premise, and that she's trying to prove something that's impossible to prove because it didn't happen. You can't prove something that's untraceable. You can't find evidence of something that does not exist, but it's being used as a way for her to manipulate the court system. And they're telling them that what she's doing is using this court system to harass and intimidate and abuse the subpoena process, which is going to be a fundamental part, I'm guessing, of their summary judgment. And then they note that she contended that tag may have been able to obscure its contacts in connection with the initial smear campaign. That is an admission that despite months of discovery, her receipt of thousands of pages of documents, and her service of dozens of subpoenas and other requests for written discovery, she has no evidence that they employed a smear campaign or did anything in August 24 other than protect their reputations as they're entitled to do when Lively's allegations were publicized. So under the law, you can actually defend yourself when someone files or when someone accuses you of a crime. And if Blake Lively began her smear campaign against them in 2024, they're allowed to defend themselves against anything that she says about them, whether it's in her own voice or through her publicist. And so if her publicist talks to the media, she can't claim that Melissa responding to those claims is retaliation. She simply can't, because you have to have motive here to cause harm. And if she's simply responding to a request from a media outlet because of a story planted by Leslie, that can't be deemed retaliation. And then they publicized and stated that there was a ruling by McSweeney versus Cohen, which is Andy Cohen of Bravo. It's a reality TV case. And Judge Lehman, who presided over the case, actually dismissed the plaintiff's harassment allegations because they were deemed not an adverse employment action under Title VII, and it could not support a retaliation claim. So publishing a letter contesting harassment allegations is not adverse employment action. So what does retaliation clause or laws mean? So it protects employees from retaliation in the workplace, meaning the employer must take some action that material affects their job. Firing, demotion, lost pay, reassignment, or harassment that deters a reasonable person from reporting misconduct. But simply publishing a rebuttal letter in order to defend themselves, even if it's harsh and even if it's critical, it's not enough unless it causes a real workplace consequence to her. And in this case, they don't have a workplace relationship anymore. And criticism is not retaliation under the law, because employers have a right to defend themselves publicly or in legal filings. And it's it's not retaliation unless it materially harms the employee's employment status. And it sets a boundary, and Lehman set a boundary in court that not every negative comment or public dispute qualifies as retaliation. So it's not retaliation for them to defend themselves because it didn't change her job, her pay, her duties, or her work environment. Even if she feels embarrassed by it, that doesn't mean that it's an adverse employment action. So even if they criticized her even to the press, that doesn't meet the legal threshold of retaliation. Defending yourself and criticizing or being truthful, even if harsh, even if they don't agree, doesn't equal an adverse employment action. Additionally, retaliation don't and cannot be claimed once the employment relationship has ended. Retaliation has to directly impact their current job. And she's trying to say now that this is a continuation of what previously happened because she has no proof that it happened before. And the reason why she is so desperate to tie content creators into this scheme is because publicly Justin said nothing at all that was unsupportive or critical of Blake, nor did anyone at Wayfair. During the promotional tour, everyone at Wayfair was only complimentary to her and only praised the work and what she contributed to the film. The public's response to her is what she's trying to blame on Baldoni. And the reason why she's trying to blame it on Baldoni is because without the smear campaign, quote unquote, you can't bring an actionable claim for retaliation because the public criticizes you. And so all Wayfair will have to do in their summary judgment is show that what they've always said, the response from the public and from the content creators and from the wider media was organic, that people were responding to the way that she decided to promote a film, and that Justin and his team had no way of manipulating the wider media in a span of 2 weeks to destroy her reputation and ruin her brands. Melissa Nathan was only brought in the beginning of August and only worked for a very short period of time. The public discourse had already started against her before she was ever played a key role in this job. And hiring a crisis manager doesn't mean that you're running a smear campaign, unless that's what Blake thinks that crisis managers do. And this is how you know they're going to use this as a defense, because it says Tag was not retained until early August 2024. And it was rendering Lively's claim that in less than 2 weeks, Tag was able to turn the entire public against her. Incredible. Stating that it's implausible for her to be able to even prove this in a court. So she can't prove untraceable. She admits that she has no evidence. And she's trying to claim that if they criticize her now, or if they say something that's truthful but harsh about her now, they're doing so because it's related to her protective activity, but their work relationship is over. They can't retaliate when they're defending themselves, and they have a right to defend themselves. But Blake has this wild belief that you don't get to say anything. I get to bring a claim and you don't get to tell me I'm wrong. They further noted this by saying unable to accept the fact that the public backlash against her was purely organic. It seeks to improperly blame Tag for her sinking reputation. Without citation to any evidence, the motion alleges that the individuals identified in this have spoken publicly about Miss Lively and this lawsuit, apparently at the behest of Tag and other Wayfair defendants. It ignores the broad scope. And he says that despite her arguments that they're not allowed to defend themselves, they are going to continue to defend themselves against the false allegations that she has made. Not only is Lively trying to control the speech of us, but she's trying to control the speech of them. And it says that Tag is dedicated to standing with the other Wayfair parties to discredit her false allegations of a orchestrated smear campaign, which is effectively telling Blake that regardless of her attempts to bully them and silence their defense, They're not going to just shut up because she deems that part of the ongoing smear campaign. And they're telling Lively that she doesn't get to use this ongoing campaign anymore because they're going to give her everything that she wants, which proves that there's no smear campaign. They're being as transparent as possible, but they're also telling her that we know you don't have evidence. We know you don't have grounds for a claim of retaliation, defending ourselves and issuing statements in defense of your accusations after your lawyers have run to the media themselves to smear us doesn't deem retaliation. At one point in time, Blake tried to tell them and tried to get a gag order and tell the court that Brian Friedman defending his clients was retaliation. That's what she views retaliation as. Lawyers have a right to defend and advocate for their clients, and defendants have a right to defend themselves, and they get to tell the world if it's true or false. And she gets to say her truth, but so do they. And when you go to a court of law, you as the plaintiff have to prove the burden here. So they're setting the stage that their summary judgment, in my opinion, is going to be based on the fact that she doesn't have evidence, but more importantly, that no retaliation occurred and that she can't accept that it's public backlash. They have so many different ways out of this case via summary judgment. It doesn't even have to do just with the public backlash because public backlash does not equate to retaliation. But if she doesn't have retaliation in this case, she can't actually bring the claims of sexual harassment forward because she never filed an HR complaint. She never went to the union. And under federal law, claims of sexual harassment have to be filed with the EEOC within 300 days of the last event, which would have been, in her case, May of 23. She was already time barred by the time she did her CRD complaint in December of 2024. And Wayfair already stated they would be using the affirmative defense that she lacks the standing and she's time barred and estoppel. Okay. When it comes to why she lacks standing, it's because under federal law, she has to go and file a charge with the EEOC. She did not. The state of California told her she had to go to the EEOC. She did not. If you don't exhaust your administrative remedies under federal law, under Title VII, no lawsuit for sexual harassment or retaliation can proceed unless they first file a charge with the EEOC and they wait for their right to sue. And if she never filed that, she's barred from bringing those claims in court. And that's a full defense for a summary judgment because it's a matter of law. So that's one way they get rid of the sexual harassment claims. But then also they can claim that she has no evidence of reporting and they don't have any liability because she never reported the harassment using their internal process. She didn't file a grievance with the union and she didn't go to HR. And they're not liable unless it was severe and pervasive and they knew or should have known and failed to act. And if she refused to sign her contract during that period, like say this happened in May before she signed anything, they can say that there was not even an enforceable employment relationship at that point because she wasn't signing her contract. And if she's not employed and she hasn't signed her contract, she lacks standing to bring that harassment claim. The 17-point agreement specifically doesn't prove sexual harassment and it actually works against her. And she claims that because they signed this, they should have known that sexual harassment occurred. And this was her, telling them that it had occurred, but it didn't because the document doesn't specify what conduct occurred. They don't specify the date of when it happened or who did it. It's vague, and it honestly just looks more like code of conduct. And if she doesn't tie a specific action in this, she can't use that as evidence that she suffered harassment. And signing the 17-point agreement in courts have routinely held that agreements to adopt standards of conduct or expectations on behavior are not evidence of wrongdoing. And just because an agreement was signed doesn't mean anyone broke a rule. And it certainly doesn't mean any harassment occurred. And they could argue that it's devoid of names, facts, or allegations, and that any evidence occurred. There's no, it doesn't reference any actual conduct. It doesn't mention the plaintiff. It has no identification of any alleged harasser. And a framework of behavior can't be used as proof. And it could be legally irrelevant and not able to survive a summary judgment. The bottom line here is that her reliance on that agreement isn't proof of harassment, and it's not only just weak, but it's meaningless because it doesn't have any evidence that anything occurred. So they know this. Wayfair knows this. She knows this. If she would have actually faced HR harassment, she would have taken the proper channels, and she didn't. So there's so many different ways they can get rid of it. They can also get rid of it via the Van Zandt action. So they can literally bring up that she never should have brought the case to court because of the way that she obtained evidence through Van Zandt, the sham lawsuit, which gave her access to evidence that she never should have been able to have, and she abused the court system, and she brought the case in bad faith. So they can use Van Zandt, they can use lack of retaliation, public criticism is not retaliation. 17-point agreement is not proof or admission of fault or guilt. And Blake didn't go anywhere or report anything and then admitted that after the 17-point agreement was signed, everything was fine. She will not survive a summary judgment. And she knows it, which is why she's so desperately trying to pin it on content creators, because she's relying on this weird delusional belief that public criticism is provoked by him so that she can sue him, so that she can get money, so she can get the sequel, so she can cover up her bad actions. But just remember that 17-appointment agreement wasn't about harassment. It was about giving her more control. And they know that, and Blake knows that. All of this was just a big facade, and everyone for months has been arguing about things that don't matter. Because at the grand scheme, her case has been frivolous since day one, and Wayfair has known that the entire time, which is why they have been just patiently riding this out. They are not actually, being super aggressive because they don't need to be aggressive. They have the truth on their side. They know her case is flimsy. They've already told the court, and they keep telling the court, and they just told her, our next step is we're going to file a motion for a summary judgment, and we're going to win. And you're not going to silence us. And the latest step that she's taken to subpoena 43 different social media accounts, many of which are not monetized and are simply people that are speaking on the story and are discussing this case and reading legal documents and trying to pit us and associate us with a smear campaign, is beginning to take steam. And as much as our side is being showcased, there's also opposing views that are giving credence to her delusional claim that we are being subpoenaed, that we are being paid by Baldoni to do this. I mean, there's a new article by Variety, who I spoke to earlier last week, and they're giving Amber Heard's attorney, the validity in this article, and basically stating, I think this is a great move by Blake's attorneys to subpoena these creators. They should uncover this campaign. They have every right to uncover this campaign. In fact, I want to just read a quote to you. The case has echoes of the Johnny Depp Amber Heard trial of 2022, in which Heard faced a barrage of criticism online. Elaine Breedhoft, who represented Heard, argues that much of it was planted by Johnny Depp's team. Depp denied all of it. They basically annihilated her, Breedhoft says. I think it's great that Blake Lively's legal team is trying to get in front of it. How else do you fight this? Elaine has no proof that any of us did this. And she has no proof that Blake Lively ever had a smear campaign against her. How can she confidently, as a female attorney that's representing women, say that me, an independent journalist, is somehow doing this for someone else? I'm not a paid bot. And then Lively's attorneys justified this to Variety. There is no silencing of content creators. They're obviously making their views known. The subpoenas to social media companies are one piece of the puzzle to connect the evidentiary dots of a campaign that was designed to leave no fingerprints. That's not what she's doing. Bullcrap. You don't need my bank account my personal information, my private IP address. You're not entitled to that so that you can connect a delusional dot. There's a smear campaign that was orchestrated by anyone. Ezra Hudson or whoever gave this speech and all of these female attorneys that are representing her should be ashamed of themselves. I sometimes get so disenchanted with lawyers because I feel like so many of them can just be bought and they'll just defend anyone or do anything and they don't care because it's money and they don't think about the harm or the damage that they're causing. Like, what right do they have to assume that just because I'm covering a legal case that I'm somehow being paid by someone? You know, the only person that pays me is Mint Mobile, who apparently is running ads on my channel. Ryan Reynolds his company has spent probably a good dime on all of the ads that my videos about this case are running. For a while, I even blocked Mint Mobile, but I can't tell you how many of you are in my comments saying Mint Mobile ads are running. Isn't that funny? The only one paying me of anyone is a company owned by Ryan Reynolds, or that used to be owned by Ryan Reynolds. I think Cassidy said that in her motion to quash. She cannot come back from this backlash. She cannot come back from this PR battle. And this PR backlash that she's facing is organic. We're not involved, and she destroyed her case. And Baldoni has told the world how he's going to get out of this and that he's put Blake on notice. And that to me gives me hope that soon the nightmare for them will be over and for all of us that are being impacted. What are your thoughts? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, besties.